of the New York City Law Board. I'd like to welcome you to our May 21st, 2015 public meeting. We first turn to a vote on the minutes from the February 12th, 2015 public meeting. Are there any corrections or comments on the minutes? Accept them. Who have a first? Thank you. A second.
I wasn't here for that meeting, so I should second.
Okay. The February. Right. Thank you. Just hold them there, right? Ms. Rivera, would you please poll the board members?
Mr. Barrett. Chief.
Yes.
Chairperson Fisher.
Yes.
Mrs. Delaney.
Yes.
Mrs. Golden Rivera.
Yes.
Mr. Chapman.
Yes.
Ms. Sheldon.
Yes.
6 yes, 1 abstain.
We now turn to a vote on the minutes from the March 19th, 2015 public meeting. Are there corrections or comments to these minutes? Somebody move to accept them? Mr. Delaney, thank you. Do I have a second? Mr. Marowitz, thank you. You please poll the members?
Mr. Barrett.
Yes.
Chief.
Yes.
Chairperson Fisher.
Yes.
Mr. Delaney.
Yes.
Ms. Golden Rivera.
Abstain.
Mr. Chapman.
Yes.
Ms. Sheldon.
Abstain.
5 in favor, 2 abstain.
Thank you. Due to Ms. Alexander's absence, there will be no executive director report today. And we will turn now to the summary calendar. There are 10 summary cases. These cases are voted on as a group. They are Don McLean, 365, 369 7th Avenue, TH 0193. Rebecca Michaels, Charlotte Peterson, and Kevin Wellich, 57 J Street, Brooklyn, TR 1128. Andrew Lee, 57 J Street, Brooklyn, TR 1129. Peter Woot, and I apologize, Ulama Vala, 57 J Street, Brooklyn, TR 1132. Adrian Truini, 118 West 27th Street, TR 1140. 135 Kent Avenue Tenants, 135 Kent Avenue, Brooklyn, TR 1159. Melanie Rio, 236 Moore Street, Brooklyn, TR 1176. Jeremy Gustin and Ben Davis, 1083, 1095 Flushing Avenue, Brooklyn, TR 1190. Don Zinzel and Manon Zinzel, 228 West Houston Street, TR 1215. Zachary Leopold, 228 West Houston Street, TR 1267. Are there any comments or questions about any of these cases? Mr. Delaney.
Yeah, I just have a couple of questions. On the second case, Rebecca Michael, Charlotte Peterson, and Kevin Wellich, the owner registered the unit and recognized the tenants as the protected occupants. Do we know if any of the 3 people who have been recognized as protected occupants held the lease or were signatories to a lease?
No, I don't know that.
Okay. Similarly, on case 4, Peter Woot and Ulaluma Zavala, do we know if either of them had a lease or both of them had a lease?
No.
Okay. And number 7, last question. Melanie Grillo, there's 3rd paragraph which says, by email to Judge Lewis, dated November 18, 2014, Eric Benson, the tenant of record in the unit, filed a statement in support of the tenant's application. Can you just define for me how we use tenant of record?
I believe it's the owner registered Mr. Benson, the original filing of the registration.
As the It's a protected occupant. So would we define tenant of record as being synonymous with protected occupant?
The application says tenant who occupied during the window period and the current tenant.
Okay. Okay. That's it?
Any other questions or comments on these cases? Is there a motion to accept these summary cases? Thank you. Do I have a second? Rivera. Ms. Rivera, can you pull the members, please?
Mr. Barrett,
Yes.
Chief Farrell, Chief,
Yes.
Chairperson, Chair Fisher,
Yes.
Mr. Davis,
Yes.
Ms. Golden Rivera, Mr. Checker,
Yes.
Ms. Sheldon,
Yes.
7 in favor.
Thank you. This has been accepted. We now come to the master cases. We have 5 master cases. We have 1 coverage case and 4 removal cases. The coverage case is Carrie Schus, Monica Forstall, and Maxwell Schus, 73 Leonard Street, TR 0974. Case.
Good afternoon, board members. On October 7, 2011, the residential tenants of the ground floor at 73 Leonard Street filed an application seeking finding that the ground floor is a 9D pursuant to 281.5 of the multiple dwelling law, and that the tenants were the protected occupants of the unit. In the report, Judge Addison recommended that the application be granted. Specifically, Judge Addison found that the front transom window satisfied the window eligibility requirement under 281.5, and that the cellar portion of the leasehold does not preclude the ground floor from coverage. While the staff agrees with the recommended outcome in the case, it does not recommend that the board accept the report in its entirety. The staff recommends that the board grant the application for coverage but reject any implication that the qualifying window must be operable or provide light and air for finding of coverage. These are issues to be resolved in the legalization process. For eligibility, the statute only requires a window opening onto a street, lawful court, or a yard. The staff also recommends that the board reject the analysis about the rear windows. In this case, the only issues in dispute were whether the unit contains at least one window that meets the eligibility requirement, and whether the cellar portion of the leasehold includes coverage for the ground floor. This case presents an issue of first impression. This is the first time the board interprets the window requirement in 281.5. As you know, the front part of the unit along Leonard Street contains 3 windows, 1 long glass window and 2 smaller windows located above the entrance doors. Of these smaller windows, the upper window is an operable transom window. The other 2 windows do not open. In her report, Judge Addison correctly determined that the transom satisfies the statutory window requirement. However, the staff does not agree that the exterior transom is the only window that satisfies the window requirement. As explained in the PO before you today, the staff recommends that the board adopt a broader interpretation of window opening to mean one that faces a street, a lawful yard, or a court. A window opening to mean one that faces a street, lawful yard, or a court, rather than one that must physically open. The statute does not require that windows be operable, nor does it require that it provide light and air. These issues should be left to the narrative statement in the legalization process. This interpretation furthers the remedial purpose of the lawful law and is consistent with the plain meaning of the statutory language. The staff recommends that the board find that the front windows directly facing Leonard Street, including the windows that do not open, meet the eligibility requirement under 281.5. Based on the recommendation that the front windows satisfy the window requirement, it is not necessary to consider the rear windows for eligibility purposes. The staff recommends that the board reject the analysis as unnecessary. In this case, the owner also challenged coverage based on the lease that includes both the ground floor and the cellar. As you know, this is significant because MDL 281.5 excludes from law floor coverage units that are located in a basement or a cellar. The staff recommends that the board accept Judge Addison's recommendation to only bar the cellar portion from coverage. The law court precedent shows that law court has granted coverage to a portion of a subject premises while denying coverage to another that does not qualify. staff recommends that the coverage application for the ground floor be granted. In her report, Judge Addison acknowledges that the tenant seek to protect their occupant status in the unit. However, she makes no recommendation on this issue. The record shows that Carrie Schuss has been in possession of the unit since 1998 and is the primacy of the unit. As such, the staff recommends that the board find that Carrie Schuss is the protected occupant of the unit. The staff recommends that the board direct the owner to register the ground floor unit within 30 days of the mailing of this order.
Questions?
I have a question about the windows. This is the purpose of the window, not just for light and air, but for emergency egress. So how's the transit limits served?
Well, the second means of egress are all issues that are hashed out in the narrative statement process, and it's also part of the plan review at DOB. Like second means of egress, light, air, safety, all of that is presented to the DOB as one plan to deal with all of those issues.
Well-
So if there's a second means of egress issue, all of that is, what we're proposing is that all of those issues, like they are for the 2811 and the 2814 buildings, should be addressed within the narrative statement process.
So was it?
And then, well, this,
Do they
this
have
case,
separate
we have some coverage for this unit yet, so it's not,
Oh, we haven't gotten there.
right.
That's to be a crazy moot question. They obviously can't leave the rear of the space, there's no room.
So what's the second?
So where's the second means? Now, the other thing is, you can maybe make one of those windows and then there's no door, so which case, door here, or a second means of egress. I mean, it just gets to be a little screwy. I mean, I'm not gonna sort of vote against this, but there's from what I can see is there's that door transom, there's a hallway, and then there's another transom.
Yes, there are two transitions.
So the air is from the door transom, and then the hall, and then there's another transom in the hall door. So that was their means of air. So, I mean, then, excuse me, then reading those dictionary definitions of what is open and closed, or what is open. That's, anyway.
Well, I was reading through it also, trying to get through the legalese of the case, and I kind of understood it, but I'd like to get some, we have a FDNY now, has a group of inspectors that are going into some of these IMDs and work this out with the chairperson. And I'd like to just take a look at it to see visually what the setup is in regards to this. Talking to Martha, she was telling me that one portion is actually at grade, whereas I understand another portion of the occupancy is a cellar, so it's more than half below grade. So that would be exempt, but this person's been living since 1998. Is actually at grade, something like that. So I'd just like to take a look at it. I agree with Michelle also in regards to the fire department needing windows for access, egress. I'm not sure about these transom windows, they're not used for egress, but I would just like to see whether this person is actually living in a cellar type occupancy with with no light and no way out and that kind of thing. I don't think that's the case, but I'd like to just take a look at it with my inspector.
So if I may, that's not a problem, but for purposes of coverage, those issues will be addressed ultimately. They need to be addressed, and to the extent they exist, they would have to be addressed. But for purposes of coverage, to get this process going, will that prevent you from voting?
No, what I understand in regards to coverage and the legality of coverage and that type of thing. So it wouldn't change my voting. I understand the concept in regards to what's being said here. but I would want to take a look at it.
Well, I think that's probably a good idea, and then I sort of noticed that Peachy, who seems to be the main architect for both, either the tenants or the landlords, that Peachy's affidavit there would seem to be absolutely correct. So then that makes me wonder who should, you know, when this narrative statement made, that somebody has to oversee it to make sure that the architect bound by his client is not excluding some of the requirements of light and air or Article 70 or whatever. So, I mean, I must say, this just amused me. It's not that I feel that there was no right to, you know, for Schultz to live there, but, I mean, you know, it's a tough town to live in, and I suppose that as far as I'm concerned, that it's the only council that should be happening. But nonetheless, it's confusion.
I wanted to respond to that. I just wanted to be clear about the process. The process is an application is filed with the Department of Buildings, an application and a set of plans. That plan and the applications are filed with the law board. So while that application is, plan is going through the DOB process, which means the architect, engineers sit with this owner and they talk about code compliance and all the objections and all the issues that this plan may present, that same plan is going through the narrative statement process with land. So that's also where they're talking about code compliance issues and what a tenant wants and prefers, and code compliance downstairs at plan review. So the process are happening at the same time. So someone is overseeing the, you know, code compliance.
Right, which you've been, over the years, you've been educating me in regards to that 5-stage process, which leads ultimately to the certificate of occupancy, that kind of thing. So that, I understand that, and I understand some of the language in regards to the process of being protected and that kind of thing.
I have a slightly different question, which is, as I understand it, the application was filed by 3 people, 3 individuals, one of whom is the child of the other 2, all of whom were in residence during the entire window period. But because the lease was held in the name of one of the individuals, we're finding only that individual to be a protected occupant. We generously extend the notion that the wife and child, quote, may be entitled to succession rights in the absence of Mr. Schuss. And this, to my experience on the board, runs contrary to the way we've handled coverage cases, and this is starting to come up. We've discussed this 2 months ago. But in this case, and the owner concedes that they were in residence during the period. So we just did a bunch of summary coverage cases where we took people's word for, we deemed people protected occupants having no idea whether their names were on the lease. But here, everybody asked for coverage. The oath judge had no opinion and didn't say, oh no, it's only Mr. Schuss because he's the one who's on the lease. Why are we headed down this road, and how do you reconcile this? How do you find consistency in what we're doing, carving out this new protected occupant status?
Section 209 of our rules, the rules that guide us in making those determinations. So we have B1 or BA, I don't remember, but it says, unless otherwise provided herein, the occupant in possession is the occupant entitled to protection. And then we have B2 that says, If you were there prior to the effective date of the law, the owner doesn't have certain defenses.
The owner doesn't have to.
Certain defenses. Like, you know, it doesn't matter whether he consented to or not. It's one of them. Doesn't
Or
matter
whether
he
the lease
consented
says
to.
no living or whatever.
No, it doesn't say that. It says the owner doesn't consent to the occupancy, the owner doesn't consent to the subdivision, and the owner doesn't consent to the sublet. That's what it says. 3 says if you're there, if you gained up or you started to occupy the unit after the effective date of the law, you must comply with one of these 3, like your prime lessee or your, I don't know the other 2, but it's after the effective date of the law. And then the 4th one says, if you're the prime lessee, you are the protected occupant of the unit. That's what it says. And here we're dealing with the prime lessee. He is an applicant. We're following the letter of the rule. Now, the other cases, there's one that I can think of where there's a wife, and the board granted coverage for the wife with no analysis. There's nothing. It's based on nothing of our rules that says it, but just sort of in the last sentence said because she's a significant other, she's granted coverage. But it's not based on anything in our rule. It's not based on the very rule that tells the board how to establish someone as a protected occupant.
Not to belabor this, but there have been cases going back to the early days of the loft law where the leaseholder was not present in the unit during the entire window period. Several cases along those lines. And in those instances, the recognition of who was the protected occupant was given to the person who was present in the unit during the window period. In this case, I don't see any reason to distinguish and say that the husband is the protected occupant and the other 2 individuals aren't. Perhaps we could, I don't know if we've ever involved ourselves with the question of if the child happens to be a minor, whether a minor child can be a protected occupant. But I just see this case as going one more step in a direction that I believe is incorrect. I think this interpretation of our rule isn't really in harmony with the plain language of the law, which pretty well says it's the definition of qualifying use is the home of 3 or more families and living independently of one another. So
Units, right?
Pardon?
Different units, not within the same unit.
That's right. And then we have definitions of units. We have definition of family in the coverage rule that tracks, I think it's MDL section 4, sub 5, or section 5, sub 4, whichever it is.
Whether marriage.
But in this instance, this isn't a subdivided unit. It's not a sublet unit. It's a unit that's been occupied residentially by a family living together for the past, decade or so. So to distinguish and say, well, he signed the lease, she didn't, therefore he's the protected occupant, you might have survivor rights. It just, to me, adds a layer of complexity that is totally unwarranted. And I'm going to vote for the case, but I hope it's brought back to us for reconsideration, because I think the board is making an error of law here. I don't think it's supportable. I think it's a tortured reading of that rule.
So under which section of 209 would you think we could grant a wife coverage?
I don't, why is 209 involved in this?
Because 209 is the rule that guides the board in making these decisions about who is the protected occupant.
If the landlord had said, you know what, I give up, I'm going to register the building, if you withdraw your application with prejudice, I don't have an issue about the egress, I don't have an issue about the basement, and I'll register the husband and the wife as the protected occupants. We'd allow that.
Sure. There's no dispute. The board is not making a decision. The decision made by the board must be based on law. It must be based on our rules. And that's what's before you today, what we think is based on 209. Now, if 209 needs to be changed, then if the board believes that 209 should be changed in some rulemaking, then that's an option the board can take. But right now, the decision is based on the rule, the language of the rule. The rule says the prime lessee, if it's his primary residence, is a residential occupant entitled to protection. That's what it says.
And yet, going back to the two cases on Kent Avenue, I believe, where the documentation, if you print out the documentation, somebody else was in residence during window period, but the landlord says registers these people.
But maybe, perhaps, I mean, I'm not saying what happened in those cases. I have no idea. We don't have the record, right? We didn't go through the entire thing. But if we have a person who signed a lease and never occupied, or occupied it for 3 months and then sublet it, then that's not, although he's the primary lessee, he can't prove that that's his primary residence. So therefore, then 4 falls off. Then he can't be found a protected occupant under 4. Then it would be the person in possession, which would go back to 1, which would be B1, unless otherwise provided herein. That's the first part of the sentence of that section. The residential occupant in possession is the resident, paraphrasing, but that's basically what it says.
I think we're wrong. I don't think it's supported under the law. The charge of the law court under Section 282 is to resolve disputes. And I think for us to go in these kinds of cases where everybody agrees the parties were in residence during the window period and denominate one as the protected occupant and not the other, we're actually running the risk of creating disputes rather than resolving disputes.
I mean, if we have the situation like Thamesshire, which still hasn't come back from out, where we had, I think it was 9 or 10 people living in there, and I don't remember, who was the prime lessee there. But, or if we had a prime lessee, the decision was that the parties needed to figure out who was a protected occupant, because the board couldn't find that 9 people could be protected occupants.
But I don't see the applicability of Thames Street to this case. Here we're not dealing with 9 people, we're dealing with a husband, wife, and a kid.
I know, but what I'm saying is that there must be a standard. And the standard is laid out in the rule. The rule is that the prime lessee is the person who's a protected occupant if they can show that if they occupy the spaces as their primary residence. And they did. And the law court rules, let's not forget, the law court rules have succession rights. So there's a provision there that accounts for families. If for whatever reason Mr. Strauss is no longer in the unit and his wife continues to occupy, she can assert her right to be found with protected occupants.
I understand that full well. I was the only occupant in my unit during the original window period. My wife, whom I married in 1992, clearly well after the window period, would have succession rights. My daughter would have succession rights. But I believe if I'd been living there with a spouse during the window period, that both of those individuals would have been named residential occupants qualified for protection. And I think we have hundreds of IMDs where we've made that kind of assignment. Similarly, in allowing these cases on the summary calendar, where the landlord says, okay, you and you are the protected occupants. We've got another case on the summary calendar where the position was the occupant, the protected occupant is so-and-so, but the landlord says it's okay, they can be the protected occupants. It's not like we're saying, wait a minute, no, we have a responsibility to make sure we've got the right protected occupant. If the parties agree, as long as there aren't 7 of them, they can be protected occupants. But here you got a husband and wife who apply for coverage together. They're not saying, I am, he is, and she. I just think this is crazy. does not use the term primacy. The primacy is all in our rules. The rules were designed.
Well, that's her point, you changed the rule. You can't change the rule right now.
Well, my point is, we've been not applying that rule to this type of circumstance for 20-plus years. If we've now discovered a reason why this rule should be applied, then I think there has to be kind of a clear policy decision. You notice a couple of months ago, the staff, partly because of the deadline that was inserted into the expanded law, created a new type of application called protected occupant. That really never existed before. You were either a residential tenant qualified for protection or you weren't. There was no teasing apart if I and my roommate lived in the loft during the entire window period. I held the lease, I paid the rent directly to the landlord, the roommate just paid rent to me. Both people were considered.
I understand, so how do we move forward at this point? Do we take this out of the findings, or what? Because we can talk about it for hours and hours, but it's not gonna help us resolve whether or not we're gonna vote on it.
Well, the entire meeting has lasted 37 minutes thus far, so I don't think we're running into the risk of hours and hours.
I think we need to find a way to move forward. You have a position, she has a position. We need to either take it out of this, because I don't really understand why it's made a point of. It's not really relevant to what the rest of the decision was. Either we take it out or we don't
Well,
vote on
I
it.
think it has other ramifications. You know, before gay marriage, if two people were living together and one died, the other had no rights. And now with gay marriage, there's certain rights. So let's say there were two gay people living there and they were not married, and only one was the leasee, the other one could be thrown out.
Well, actually,
Is that right?
No, that's incorrect. When the Braschi decision came out under the rent stabilization law, we amended our coverage regulations to track that exact circumstance.
What do you mean? But if the two people, let's say, are living together or not?
Yes,
Okay.
to provide for succession.
All right, you know, we did make these recommendations for the Assembly and the Senate for the, you know, for new amendment to law. Maybe we ought to try to add this to it. So it's not so ambiguous any longer.
Well, the problem is there's no need to address it in the law because the law is silent on this. This is all us in our rules, and I believe applying a rule to a circumstance where it doesn't need to be applied. As we know, I mean, you're well aware, the name escapes me right this instant, but the case where a couple had sublet their loft during the entire original window period to take their child to a more sedate environment. Lo and behold, they were the prime lessees. They weren't present during the entire window period. They were found not to be the residential occupant qualified for protection, but the subtenants were. There was a dispute. Here, there's no dispute.
There's no dispute, but there has to be a decision by the board, and the board has to base its decision on our rules. And with regard to your comment, Ms. Shelton, the reason why it's in there is because the tenants did ask for it. It's a part of their application, and that's why we made it part of the order.
They asked to be found, to both be found.
Yes, they asked to
Right.
be found protected occupants, that's why it's there.
Right. If I make a motion to omit that paragraph, will you second it, Michelle?
No, because she just said it was a request by the other occupants to have a determination on it, so I don't think we can do that.
They weren't requesting, it's not, the husband and wife are not at odds here.
No, but I think what I understand from what Martha said, Deputy General Counsel, was that because the tenants, these other occupants had asked for a finding on it, I don't think we have the ability to not make a finding on it, unless I'm mistaken.
Well, again, three, I believe, unrelated adults, none of whom I believe are married to each other, Rebecca Michael, Charlotte Peterson, and Kevin Wellick, we just found on the summary calendar to all be protected occupants of one unit without any scrutiny or applying any test. Here, two people say we want to be covered, and we're applying a test. Which way is it? It doesn't make sense.
The board is not making a decision. The board is accepting its filing that was made on behalf of the owner. It's not making a decision.
In the summary calendar case.
Yes.
And in this case, did the owner say, oh no, if you find anybody covered, it can only be Mr. Schuss, but you can't find his wife covered because her name's not on the lease?
No.
No. We're just taking this on ourselves.
We're making a decision based on the rules. But the proposal is to make a decision.
The rule that relates to subdivision, subletting, and assignment.
The rule that relates to determining how to make a decision on who's a protected occupant. Entitled to protection.
I think that this is an important issue, but I think it should have its own time on an agenda to look at that rule. And I think we should either table this now or vote on this action, but I don't think that we can discuss the rule at this time. I think it should be put on the agenda at a later date.
Are we tabling? What are we doing?
I make a motion to
The table, approve this case?
because we can look at the rule in the future, but if we have a case in front of us, so we have to use today's rules. So I'm making a recommendation that today we use today's rules.
Second.
I second.
Mr. Delaney, Ms. Rivera, any poll members?
Mr. Barrett,
Yes.
Chief,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
Yes.
Ms. Bowden Rivera,
Yes.
Mr. Chaka,
Yes.
Ms. Shelton.
Are we voting on the case?
Yes.
Okay, yes. I wasn't.
No, yes. This is my motion.
Seven in favor.
That's all.
Seven in
No,
favor.
I was just.
Thank you. Next, we have 4 removal cases. These cases are usually voted on as a group. They are Uzi Ben Abraham, 1151 Broadway, LE 0642, West Tech Corporation, HDFC Inc., 445 465 West Street, LE 0646, Wayne Management Condominium, 115 123 Broadway, LE 0647, Fort Great Jones Holdings, LLC, Fort Great Jones Street, LE 0648. Comments, questions on these cases?
Question on the West Back one, is this a giant building over there? It's been like the first walk. Is it small, but I didn't realize the whole thing was not a walk. Am I just reading this?
No, there are a couple of spaces in that huge building that were INDs, yes. And this order seeks to remove the building
I have a
from.
question. When did they declared INDs? They declared INDs before HUD?
I think they were already had. I think they were already governed by HUD. I think that was a defense that was used by the owner at the time.
I think that's correct.
I think that's correct. I did not know that people were living there before HUD took over that space, that building.
Yeah.
Okay.
Anyone else? A motion to accept these cases? Ms. Shelton, thank you. Have a second? Thank you. Mr. Rivera, any poll members?
Mr. Barrett,
Yes.
Chief,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
Yes.
Ms. Bowden Rivera,
Yes.
Mr. Chaka,
Yes.
Ms. Shelton,
Yes.
seven in favor.
Thank you. This will conclude our May 21st, 2015 Loft Board public meeting. The date of the next public meeting will be circulated once we have a room. And please remember that our scheduled meetings is posted on our website. Board members, please sign and hand in your attendance sheets.
I'm sorry, can you clarify? I think we have a meeting
We
scheduled.
do, we need to reschedule it from the 18th,
It's not going to be the 18th?
not the 18th.
That, we're certain of
We are
that.
certain of that.
Oh, boy.
My fault.
I mean, already, they plans to get out of the city, back especially for this meeting, right, on next month, and now you say it's gonna change?
Yes.
Do we have any idea?
No question.
We might be able to schedule it for that morning.
Send me an email out and what about commissions and antiques,
Let's look, we may have it on a different space.
If we schedule it for that morning, flying back from out of state, I probably won't be here by morning.
Well, what time?
I don't know, taking something like a 6, 7 o'clock flight from Chicago.
Just to come here?
Yeah, from here, right? You know, from I missed one meeting this year, also because the meeting was great, and I had made plans.
All right, let me know your plans, maybe we can get you over here.
Yeah, well, I can tell everybody what I'm doing, come on.
Sure, of course.
When we discuss the rules, would it be possible to send us a copy of the rules before that meeting, so we can review it and be better prepared? In that binder. You probably have it in the binder, but I do.
Well, it's changed.
Oh,
I'll send you.
okay.
So do we have a sense how this is going to play itself out?
The meeting or?
The meeting, yeah.
We're going to check for space, we're going to see if it works with his calendar, if not, we'll send another date around as quickly as possible.
But it might be
Maybe that morning.
the morning of the 18th, but it won't be the afternoon of the
It will not be there.
Okay.
I apologize. Duty calls. Other duty calls.
There are.
I guess if as soon as that kind of thing's known, if it could be circulated. I know with Lanny out of town, it's probably been a little discombobulated.